Hi guys, as I was requested to make a video on Mr. Nettleship vs. Weston case law, I made this one for you. So keep enjoying and learning.
Hello, Mr. Nettleship.
Hi, Mrs. Weston. How are you?
I am good. Actually, I need a favor from you.
Sure. Tell me, what is it?
I want to learn driving. And you know my husband is too busy, so please can you help me?
Mrs. Weston, I would love to help you, but I am not a good driver either.
That's not a problem. Please, you are such a good friend of mine. You can teach me in my husband's car, and it is insured, so there is no problem.
Okay, but I want to see the insurance papers so that I am satisfied.
Why not? Thank you so much. Tomorrow morning come to my home, we will have some tea, and I will show you the papers there itself.
Okay, cool. Good night.
Good night.
Hello, Mr. Nettleship, how are you?
I am good, Mr. Weston, thank you.
Thank you for giving my wife driving lessons. She was asking for it for a long time, but I am busy with my work. You can teach her in my car. We have a fully comprehensive insurance which will cover you as a passenger in case of an accident. You can see the policy. My wife is coming with the papers. But I have to go, I am getting late. See you soon.
Sir, I am on behalf of Mr. Nettleship. He has got his knee fractured because of the negligence of Mrs. Weston while giving her the driving lessons. And thus, we want the damages.
Sir, but Mr. Nettleship was well aware of my lack of skill. And the court should make some allowance, because I could not be expected to drive like an experienced motorist.
Applying a lower standard to the learner driver, because the instructor was aware of her inexperience, would result in complicated shifting standards. It would imply, for example, that an inexperienced doctor owed his patient a lower standard of care if the patient was aware of his lack of experience. The standard of care for a learner driver would be the usual standard applied to drivers, that of an experienced and skilled driver. The instructor was also responsible for the accident, as he was partially in control of the car, and thus he will only be able to recover half of his damages due to contributory negligence.
Mrs. Weston was rightly convicted of driving without due care and attention. In the criminal law, it is no defense for a driver to say I was a learner driver under instructions.
I hope you understood this, that learner drivers are expected to attain the same standard as experienced drivers, even on their first outing behind the wheel. So, drive safe and be safe. And I hope my family will at least drive carefully, because they knew now that there are no excuses in case of any default. Bye. See you soon.